Marcus Webb had surveyed thousands of acres in his career. 41 years of drawing boundary lines other people would spend the rest of their lives arguing about. He never once thought he'd need his own tape measure to defend 6 feet of dirt behind his garage. The knock on his door came at 4:52 p.m. on a Tuesday in April, and it wasn't a neighbor. It was Deputy Ray Holloway of the Caldwell County Sheriff's Office, hand resting near his belt, expression somewhere between apologetic and irritated. "Sir, I've got a call about a trespassing situation. Property owner says you're refusing to leave a section of common area and that you've posted a threatening sign." Marcus, 61 years old, silver-haired, still built like the man who used to haul survey equipment through Ohio farmland for a living, looked past the deputy toward his own backyard, toward the wooden stake he had driven into the ground 3 days earlier, toward the laminated sign zip-tied to that stake, printed in block letters, "Private property, legally surveyed boundary line, no trespassing beyond this marker." "Deputy," Marcus said, "that sign is 11 feet inside my own property line. I know that because I'm the one who surveyed it." The deputy exhaled through his nose, the exhale of a man who had already sensed this call was going to be a headache. "The complainant says it's on HOA common ground." "The complainant," Marcus said, "is wrong, and I'd bet good money she knows it." He was talking about Diane Kessler, president of the Cedar Hollow Estates Homeowners Association, whose son-in-law's fence line had been eating into Marcus Webb's backyard for the better part of 2 years, and who, when confronted with an actual licensed survey proving it, had responded not with an apology, but with a phone call to 911. This was the moment the whole neighborhood would eventually be talking about. Not the fence, not the fine. The moment a retired surveyor stood in his own yard, on his own land, and was accused by his own homeowners association of trespassing on it. Deputy Holloway spent the better part of 20 minutes standing between 2 half-finished sentences, one from Marcus and one, over the fence line, from Diane Kessler herself, who had arrived on foot within minutes of placing the call, as if she'd been waiting nearby for exactly this outcome. She stood with her arms folded, a clipboard tucked under one elbow, the kind of clipboard Marcus recognized from 6 years of watching her carry it to every board meeting, every walk-through inspection, every occasion where she needed to look like she was operating under some kind of official authority. "He's been told before," Diane said to the deputy, not to Marcus, "that this is a shared concern between our families. He decided to escalate it himself, instead of going through the proper channels." "The proper channels," Marcus said, "would be the ones I used. I hired a licensed, bonded, independent surveyor. I have a signed and sealed document. That's about as proper a channel as exists in the state of Ohio." Holloway looked at the stake, looked at the sign, looked at the 6 feet of grass between the stake and the collapsed section of fence, still lying in Marcus's flower bed, from the March windstorm, and made a decision that would end up mattering a great deal in the months to come. He wrote down, verbatim in his report, that he personally observed the marked survey stake, that the location was consistent with a boundary marker rather than a common area obstruction, and that no criminal trespass had occurred on either side. "Ma'am," he said to Diane, "I don't see a crime here. This looks like a civil property dispute, and that's not something I can resolve standing in a backyard." Diane's jaw tightened in a way Marcus would come to recognize over the following months as her tell, the look of a woman used to being the last word in every room she occupied, encountering, for once, a room she didn't control. "This isn't over," she told Marcus, loud enough for 2 of his neighbors to hear it from their own yards. "No," Marcus said quietly, once the deputy's cruiser had pulled away, and it was just the 2 of them and a fence line between properties that both of them, in different ways, believed they owned. "I don't imagine it is." Linda watched the whole exchange from the kitchen window, phone in hand, in case she needed to call anyone else, and later told Marcus that the thing that had frightened her most wasn't the deputy, or the sign, or even the accusation itself. It was the calm certainty on Diane Kessler's face as she walked away. The look, Linda said, of a woman who fully expected this to work, who had made that call assuming a sheriff's deputy would simply take her word over a stranger's stake in the ground. Because that was how it had always gone before. Drop your city, and tell me, do you actually live under an HOA right now? I want a head count in the comments of how many of you are watching this from behind enemy lines. Cedar Hollow Estates sat on the outskirts of Millbrook Falls, Ohio, a town of 11,000 people, 40 minutes northwest of Columbus, the kind of place where the biggest news of any given month used to be whether the county fair would rain out. Cedar Hollow itself was a development of 206 homes, built between 2003 and 2011, brick and vinyl colonials on quarter-acre lots, curving streets named after trees that had been bulldozed to make room for the streets. Sycamore Ridge Lane, Elm Hollow Court, Maple Crest Drive. Marcus and his wife, Linda, had bought their house at 1442 Sycamore Ridge Lane in the spring of 2006, back when Marcus was still working full-time for the Ohio Department of Transportation as a licensed professional land surveyor. The kind of job where being off by half an inch on a highway right-of-way could cost the state 7 figures in litigation. He'd retired in 2019 with a pension, a workshop full of surveying equipment he refused to sell, and a habit, Linda called it a compulsion, of noticing property lines everywhere he went. Grocery store parking lots, his daughter's new subdivision in Dayton, the neighbor's mailbox post, which Marcus was fairly sure sat 4 inches over the correct right-of-way. In the early years, Cedar Hollow Estates had been, by most accounts, an unremarkable place to live, in the way unremarkable is usually a compliment for a subdivision. There'd been a rotating cast of board presidents through the 2000s, mostly forgettable, mostly concerned with keeping the shared pool clean and the entrance signs landscaping from dying every August. It was somewhere around 2018, 2 board presidents before Diane Kessler's current run, that the association's character started to shift, according to the longtime residents Marcus talked to later. A gradual tightening of enforcement, a growing reliance on fines as a line item in the annual budget rather than a last resort, a board that increasingly treated the CC&Rs less like a shared agreement among neighbors and more like a private rulebook to be wielded at their discretion. Diane Kessler had been on the board in some capacity since 2015 and board president since 2019, re-elected each February by a small, loyal cluster of proxy votes she collected door-to-door herself, usually from residents too busy or too indifferent to read what they were signing. Cedar Hollow's Homeowners Association governed the neighborhood through a 58-page declaration of covenants, conditions, and restrictions, recorded with the Caldwell County Recorder's Office in December 2003, later amended in 2015, and again in 2021. Both amendment cycles pushed through, as Marcus would later discover, during years when Diane Kessler sat on the board's governance committee. The current board consisted of 5 members: President Diane Kessler, Vice President Todd Averill, Treasurer Susan Marsh, and 2 at-large members, Gary Poole and Renata Hicks. Todd Averill ran a small insurance agency in town and had been on the board for 4 years, largely by his own later admission, because nobody else had volunteered the year he was recruited. Susan Marsh worked part-time at the county auditor's office and handled the association's books with a level of detail that would later prove more useful to Marcus's case than to Diane Kessler's defense of it. Gary Poole was retired like Marcus, a former manufacturing plant supervisor who golfed twice a summer and mostly wanted board meetings to end on time. Renata Hicks, the quietest of the 5, worked as a school librarian and had joined the board in 2021, hoping, she'd tell Marcus much later, to make the community a little more organized, a hope that had curdled somewhere around her 2nd year into something closer to quiet dread every 2nd Tuesday of the month. Diane's daughter, Ashley Kessler Byrne, and her husband Chase Byrne had bought the house at 1444 Sycamore Ridge Lane, directly behind Marcus and Linda's property, in the fall of 2022. Ashley had grown up 2 streets over, in the house Diane and her husband still lived in, and buying just 1 street away from her mother had seemed, at the time, like a sweet arrangement, the kind neighbors mentioned approvingly at the mailbox. Within 4 months of closing, Chase had replaced the original wooden privacy fence, a fence that had stood in the exact same position since 2007 without a single complaint, with a taller vinyl fence installed by a contractor who apparently didn't believe in consulting a plat map before pouring concrete footers. There was history behind Marcus's patience, too. History that had nothing to do with Chase Byrne specifically. Cedar Hollow Estates had, in its 2nd decade, developed a quiet reputation among a certain kind of resident for being a neighborhood where disputes were better absorbed than fought. The Petersons on Birchwood Lane had spent 18 months in the mid-2010s contesting a fine over a detached storage shed before simply paying it and putting up a privacy hedge instead, telling anyone who asked that it wasn't worth the aggravation. The Nguyen's on Maple Crest had let a disagreement over a shared driveway easement go unresolved for 3 years, rather than involve the board, on the theory, widely shared among the older residents, that once the board got involved in a dispute between 2 neighbors, both of them tended to come out the worse for it. Marcus had absorbed that same lesson without ever quite naming it to himself, a kind of learned caution about escalating anything to Diane Kessler's desk, since matters that landed there rarely got smaller. Marcus noticed the shift almost immediately. He'd surveyed his own lot back in 2019, mostly out of professional habit, mostly because a man doesn't stop being a surveyor just because he stops getting paid for it. He kept the plat drawings in a fireproof filing cabinet in his garage, alongside the county-recorded legal description of his property, Lot 47, Cedar Hollow Estates Section 3, recorded in Plat Book 22, page 114 of the Caldwell County Recorder's records. When the new fence went in, Marcus walked the line with his own equipment on a Saturday morning in November 2022, just to be sure his memory wasn't playing tricks on him. It wasn't. The new fence sat, at its worst point, 11 inches over the boundary, and, running the full 72-foot width of the shared property line, encroached onto Marcus's land by an average of 8 inches. Enough that his gutter downspout now drained directly onto what was legally the Burns side of a fence that was, itself, sitting on Marcus's dirt. He didn't make a scene. He was a patient man. 41 years in a profession built on precision had taught him that. He mentioned it to Chase Byrne over the fence one Saturday, in a friendly, neighborly tone. "Hey, just so you know, when I had this surveyed a few years back, the line runs about here," and Chase had shrugged and said he'd look into it. He never did. Marcus mentioned it again in March 2023, this time bringing over a printed copy of his own 2019 survey sketch, hand-drawn but professionally accurate, and leaving it with Chase to think over. Same shrug, and the sketch, Marcus would notice months later, ended up recycled with the rest of the Burns junk mail. He let it go through that summer, then the fall, then the following spring, because Linda kept telling him to pick his battles, and because for 2 years, that was exactly what he did. A strategy of patience that, in hindsight, he suspected had only convinced Diane Kessler and her family that the matter would simply keep being ignored indefinitely. What changed everything was the storm. Now that you've met Marcus, has your HOA ever done something that made your blood absolutely boil? Tell me the worst thing your association has ever pulled, because I guarantee someone in these comments has a story worse than this one. In late March of this year, a windstorm tore through Caldwell County, with gusts recorded at 61 miles an hour by the National Weather Service station in nearby Danville. It knocked down half a dozen trees across Millbrook Falls, took the roof clean off a pole barn on Route 9, and, closer to home, split the fence between Marcus's lot and the Burns clean down the middle, toppling an 18-foot section directly onto Marcus's flower beds. When the insurance adjuster came out to assess the damage to determine liability, the question of exactly whose property the fence sat on suddenly wasn't academic anymore. It was the entire case. Marcus, tired of being ignored, hired an independent licensed surveyor. Not himself. He wanted a neutral, court-admissible document, since he understood better than anyone that an interested party's own survey carries less weight in a dispute. To come out and produce a formal, recorded boundary survey. The surveyor, a woman named Priya Chandrasekaran of Chandrasekaran Land Services, LLC, spent 4 hours on the property on April 9th and delivered her signed and sealed survey on April 14th. It confirmed everything Marcus already knew, in language a court could not ignore. The fence line, both the original and the rebuilt section, sat an average of 8.4 inches onto Lot 47, with the worst encroachment at 11.2 inches near the northeast corner, adjacent to the shared drainage easement. Marcus did what any reasonable homeowner would do. He sent Chase and Ashley Byrne a certified letter on April 16th, enclosing a copy of the survey, requesting the fence be rebuilt on the correct line when it was replaced, and offering, generously he thought, to split the cost of moving it, since the original error predated their ownership. He received no response. So on April 21st, Marcus did the second reasonable thing a surveyor with 4 decades of experience would do. He marked the boundary himself, properly, the way it's supposed to be done. He drove a treated 4x4 wooden stake into the exact corner coordinate identified in Chandrasekaran's survey, 11 feet inside his own property line from where the collapsed fence had stood, well clear of any shared easement, and he zip-tied a laminated sign to it, not to threaten anyone, to document, permanently and visibly, where the actual line sat, because he'd learned the hard way that verbal conversations over a fence get conveniently forgotten. The sign read exactly what he intended it to read: private property, legally surveyed boundary line, per recorded survey dated 4/14. No trespassing beyond this marker. Diane Kessler saw it 4 days later, and that was the afternoon Deputy Holloway's cruiser rolled up Sycamore Ridge Lane. According to the police report he would later file, case number 25-04127, Caldwell County Sheriff's Office, Diane Kessler stated she had walked onto the Webb property to inspect a common area drainage concern when she encountered the sign and felt threatened by its aggressive and hostile language. She stated that Marcus Webb had posted the sign on Association Common Property, and that she believed he was attempting to unlawfully claim land that did not belong to him. There was, in point of fact, no HOA common area anywhere near that corner of Lot 47. The nearest common area, a 0.6-acre drainage retention pond, sat behind Lot 51, 3 houses down. Diane Kessler, who had lived in Cedar Hollow Estates for 19 years and who had personally signed off on the original 2003 plat approval as a founding board member, knew precisely where the association's common ground began and ended. She had, in fact, cited 3 other homeowners over the preceding 5 years for minor encroachments onto that very drainage pond area. Section 6.2 of the CC&Rs, Common Area Encroachment and Unauthorized Use, with fines starting at $150, $250, over a sign on his own land, against a man named Marcus Webb, who has a licensed survey proving he was right. Is this even legal where you live? What would you have done in his position? The fine notice arrived on April 29th, hand-delivered and taped to Marcus's front door in a manila envelope, because Diane Kessler liked to personally deliver escalation letters when she believed a resident needed, in her words to the board that week, a firm reminder of whose neighborhood this is. The letter cited 2 alleged violations. First, Section 7.4 of the CC&Rs, Signage and Postings, which prohibited any handmade, non-uniform signage visible from any street or adjoining property, excepting realtor signage and holiday decorations not exceeding 30 days in duration. Fine, $150, effective immediately. With an additional $25 per day, the sign remained posted. Second, and this was the one that made Marcus set his coffee down and read the letter twice. Section 4.12, Boundary Disputes and Encroachments, which stated that any homeowner alleging a boundary dispute with an adjoining property owner shall submit such dispute to the Board of Directors for mediation prior to taking unilateral action, including but not limited to erecting markers, fencing, or signage disputing said boundary. Violation of this provision carried a fine of $100, plus a requirement that the homeowner cease and desist all unilateral boundary actions pending board review. Marcus read Section 4.12 a third time because something about it struck him as familiar in a way that made his stomach turn. He pulled the original 2015 amendment to the CC&Rs from his files, the year the section had been added, and cross-referenced the board meeting minutes archived on the HOA's own management portal. Section 4.12 had been proposed and drafted by then-Board Secretary Diane Kessler, adopted by a 4-1 vote at a meeting where only 14 of 206 homeowners were present, well short of any meaningful mandate, though technically above the association's quorum requirement of 10%. In other words, the rule that now criminalized Marcus for marking his own surveyed boundary had been written 9 years earlier by the very woman now enforcing it against him. A rule that, as far as Marcus could determine, after 2 hours combing through 8 years of published violation notices obtained from the HOA's online portal, had never once been enforced against anyone else. Not against the homeowner on Birchwood Lane, who'd put up a decorative split-rail fence disputing a side yard easement in 2019. Not against the couple on Maple Crest, who'd staked out a garden bed extension in 2021 after a disagreement with their neighbor over a shared drainage swale. It had been written, and it had sat dormant, for 9 years. Until the one time a boundary dispute happened to involve Diane Kessler's own daughter and son-in-law standing on the wrong side of a licensed survey. Marcus wrote a response letter on May 1st. He was calm. He was, if anything, too calm for what was coming. The calm of a man who still believed at that point that documents and facts would settle the matter, because in 41 years of surveying, documents and facts had always been the thing that ended arguments. He enclosed a full copy of Chandrasekaran's signed and sealed survey. He noted, politely but pointedly, that the sign sat entirely on his own property, that Section 4.12's unilateral action clause could not reasonably apply to a homeowner marking his own confirmed boundary rather than disputing someone else's, and that the association's own enforcement history showed the rule had never been applied to any resident besides himself. He closed by requesting the fines be rescinded and the matter closed. He copied Renata Hicks and Gary Poole directly on the letter, a small, deliberate choice, made on the theory that a board member who never saw the full correspondence couldn't be blamed for rubber stamping whatever Diane Kessler told them was true, but a board member who did see it and stayed silent anyway had made a choice of their own. Diane Kessler's response, delivered 8 days later, was not a rescission. It was a notice of continuing violation and escalating fine schedule, informing Marcus that the daily fine had increased to $50 per day, retroactive to April 25th, that his total balance as of the letter's date stood at $1,200, and that failure to remit payment within 30 days would result in the matter being referred to the association's collection council for lien placement pursuant to Section 9.3 of the CC&Rs and Ohio Revised Code, Chapter 5312. There was also a line, near the bottom, that Marcus would read to Linda out loud that evening, twice, because he couldn't quite believe a homeowners association had put it in writing. The board additionally notes that continued hostility toward association leadership, including, but not limited to, law enforcement contact regarding lawful board inspection activity, may result in referral to the association's legal counsel for a restraining petition. Marcus had not been hostile toward anyone. He had stood in his backyard on April 25th and calmly told a sheriff's deputy that the sign sat on his own land. The law enforcement contact the letter referenced was the 911 call Diane Kessler herself had made. Linda, reading over his shoulder, said the thing out loud that Marcus had been circling for a week without quite landing on. "She's not trying to fix a fence line, Marcus. She's trying to make an example out of you, before anybody else in this neighborhood gets the idea that they can push back." Marcus didn't answer right away. He was thinking about Renata Hicks, actually, the quiet board member who'd voted against something at a meeting 2 years back. A vote he only half remembered because at the time it hadn't seemed to matter to him. He filed the thought away without knowing yet how much it would matter later. Marcus just filed his first public records request against his own HOA. Was that the right move, or should he have lawyered up immediately? Tell me your strategy. What would you have done first? The lien threat arrived formally on June 3rd, a certified letter from Halbrook & Vance, LLP, the association's retained collection counsel, informing Marcus Webb that his outstanding balance, now $2,850, encompassing the escalating daily fines, a $150 administrative processing fee, and $200 in legal review costs, would result in a certificate of lien being filed against 1442 Sycamore Ridge Lane with the Caldwell County Recorder's Office within 15 days, absent payment in full. Marcus had spent 30 years of his career reading legal descriptions, easements, and encumbrances recorded against properties across the state of Ohio. He knew exactly what a lien meant, knew exactly how it could metastasize. Unpaid HOA liens in Ohio could, under the right conditions and with enough time, snowball into foreclosure proceedings. And while that outcome was rare, it was not impossible, and it was not something Marcus intended to let ride on the assumption that reasonable people would eventually see reason. What stung more than the money was what happened at church that Sunday. Linda came home from the grocery store on June 5th and found 3 separate neighbors had, in one form or another, asked her whether it was true that Marcus got in trouble with the police for threatening someone with a sign. The story had traveled through the neighborhood group chat, administered, it turned out, by Susan Marsh, the HOA treasurer, in a form roughly 70% removed from what had actually happened. By the time it reached the Delgados at 1451 Maple Crest, the story was that Marcus Webb had pulled a gun on his neighbor over a property line, a detail that existed nowhere in reality and that Marcus suspected, though could never prove, had been embellished somewhere along its journey through Diane Kessler's social circle. At the neighborhood's 4th of July block party, technically not an HOA event, but attended by most of the same people who served on the association's various committees, Marcus noticed conversations quieting when he walked past. Todd Averill, the vice president, made a point of steering his family to the far side of the pavilion. Gary Poole, one of the at-large board members, who had golfed with Marcus twice a summer for the better part of a decade, offered a tight nod and nothing more. It was, Marcus would later say, the specific cruelty of small-town HOA politics. The fine was recoverable. The lien was recoverable. What was harder to get back was 19 years of being the guy people waved to. The Ferraro fine had started, as these things so often did in Cedar Hollow, with a single letter taped to a front door. Anthony had come home from his father's discharge appointment at the rehabilitation hospital in November 2023 to find a manila envelope wedged behind the storm door, informing him that the ramp his father would need to enter his own home had been photographed by a concerned neighbor and referred to the Architectural Review Committee for non-conforming exterior modifications. He'd called the HOA's management line the next morning, expecting a conversation about permits, and instead reached an answering service that took a message nobody returned for 11 days. By the time anyone from the board called him back, the fine had already been assessed retroactively to the date of installation. There was a second family that summer, feeling something close to the same isolation. though Marcus didn't learn their story in full until August. The Ferraros, at 1478 Elm Hollow Court, had spent nearly a year fighting a fine of their own, $175 a month, for what the board's violation notice described as an unauthorized accessibility modification, which turned out to mean the aluminum wheelchair ramp Anthony Ferraro had built for his father, who'd moved in with them after a stroke in late 2023. The board's position, laid out in a letter signed by Diane Kessler, was that the ramp violated Section 8.1 of the CC&Rs governing uniform exterior modifications because it had not been submitted for architectural approval before installation, and that its unpainted aluminum finish detracted from neighborhood aesthetic standards. The Ferraros had quietly paid 4 months of fines, nearly $700, before giving up and simply stopping payment, assuming, as so many Cedar Hollow homeowners had learned to assume, that further pushback was pointless. Marcus didn't know it yet, but the day was coming when the Ferraros' ramp and his own survey stake would end up mentioned in the same sentence, at the same meeting, in front of the same 130 homeowners. There was a particular Tuesday in late June that Marcus would come back to in his mind more than any other that summer. He'd gone to the hardware store on Route 9 for a bag of quick-set concrete. Nothing to do with the dispute, just a loose fence post on the side yard that had nothing to do with the burns at all. The cashier, a woman named Pat who'd rung him up at that same register for a decade, hesitated, with his change in her hand, and asked, quietly, whether it was true he'd been banned from the pool. He hadn't been. There was no such rule, no such vote, nothing in any minutes Marcus had read. But the rumor had reached the cashier at the hardware store, 3 streets and 1 shopping plaza away from Cedar Hollow's gates, which told Marcus something about how far and how fast a story could travel once somebody with a clipboard decided it should. He came home that day and sat with Linda on the back porch, looking at the stake in the yard, the same 6 feet of grass that had somehow become the most contested real estate in Caldwell County. "You know what the worst part is?" Linda said. "It's not even about the 8 inches anymore. Nobody in that meeting is going to care about 8 inches. They're going to care about whether Diane Kessler thinks the rules apply to her family the same way they apply to everyone else's." Marcus turned that over for a while. "Then that's the case we build," he said. "Not the fence, her." Linda found Marcus in the garage on the night of July 9th, sitting at his workbench beside the same steel filing cabinet that held every survey he'd ever drawn, staring at a stack of correspondence 3 inches thick. "You've been quiet all week," she said. "I keep thinking," Marcus said, "that I spent my whole career making sure lines were exactly where they were supposed to be. 1/2 inch mattered, 1/4 inch mattered. And now I've got a woman with a real estate license and a laminating machine telling a county sheriff's deputy that I'm the criminal for knowing where my own dirt starts. So what do we do?" Marcus looked at the filing cabinet a long moment. "We do what I know how to do," he said. "We build the file." Marcus's first move wasn't a lawyer. It was a public records request. Ohio's Public Records Act didn't technically apply to private homeowners associations the way it applied to government bodies, but Cedar Hollow Estates' governing documents, Article 11, Section 11.1, obligated the board to make certain financial and meeting records available to any member in good standing upon written request, a provision most residents didn't know existed because most residents had never read past the first page of the CC&Rs. Marcus had read every page, twice, decades earlier, as a matter of professional habit, and he still remembered the section number cold. He submitted a formal written request on July 11th for 5 years of board meeting minutes, the association's complete violation and fine enforcement log since 2015, and copies of all collection referrals sent to Halbrook and Vance over the same period. Ohio law and the association's own bylaws gave the board 30 days to respond. Diane Kessler took 41, and when the documents finally arrived, heavily redacted in places that made Marcus laugh out loud in his kitchen. They told a story more damning than he'd expected, even in his most cynical moments. The enforcement log confirmed what Marcus had already suspected. In 8 years of the fine schedule under Section 4.112 existing on the books, it had been invoked exactly once, against him. Meanwhile, the log showed at least 11 instances of homeowners violating far more visible provisions of the CC&Rs: unapproved paint colors, oversized sheds, a boat parked in a driveway for 6 consecutive months in violation of Section 5.8, where fines were either never issued or were issued and then quietly waived. 3 of those 11 waived fines belonged to addresses Marcus recognized: Todd Averill's own home, a rental property owned by Susan Marsh's brother-in-law, and this one made Marcus set his coffee down for the second time in 3 months: 1444 Sycamore Ridge Lane, the Burns. Diane Kessler's own daughter and son-in-law had received a written violation notice in 2023 for an unpermitted shed, a $300 fine that appeared in the log as assessed and, 4 lines later, waived per board discretion 9/14/2023, with Diane Kessler's own initials beside the waiver. Buried 3 pages deeper in the same log, in an entry Marcus almost skipped past, was the Ferraro ramp, still active, still accruing, up to $2,275 as of the log's most recent update, the single largest outstanding balance in the entire 8-year record, besides Marcus's own. The financial disclosures Marcus received were partially redacted, but what wasn't redacted raised its own questions. The association's reserve fund, required under Ohio Revised Code Chapter 5312 to be maintained at a level sufficient to cover major anticipated repairs, replacement of shared infrastructure, and the retention pond stormwater system, had declined from $184,000 in 2019 to $61,000 in the most recent filing, a drop the minutes attributed to unplanned drainage system repairs, without itemizing a single invoice, contractor name, or work order. Marcus, who had spent a career estimating the actual cost of civil infrastructure work, did some rough math on a legal pad and concluded that whatever work had supposedly consumed $123,000 of the association's reserves, it hadn't shown up anywhere on the ground. The retention pond behind Lot 51 looked, by his own eyes and by 3 separate neighbors' testimony, exactly the same as it had in 2019. He wasn't ready to call it theft. He was, however, ready to call it a pattern, and patterns were something Marcus Webb had spent his entire adult life documenting for a living. He spent 3 evenings that week building what he privately called, only half joking, the exhibit binder, a 3-ring binder organized exactly the way he used to organize evidence for right-of-way disputes at the Department of Transportation. A tabbed timeline, a copy of Chandrasekaran's survey behind the first tab, the certified letters behind the second, the enforcement log's most relevant pages highlighted in yellow behind the third, and the financial disclosures, annotated in his own careful hand, behind the fourth. Linda found him at the kitchen table past midnight more than once that week, and though she never said so directly, Marcus suspected she found something almost comforting in watching him work a problem the way he always had, methodically, without panic, 1 tab at a time. "You know this isn't a highway easement," she told him once, not unkindly. "No," Marcus agreed, "but the same rule applies. Whoever brings the better documentation wins. It's just usually the state that has it. This time, it's going to be me." The second move was the lawyer, not because Marcus needed someone to tell him he was right, but because he needed someone who could tell a court he was right, in language a court would respect. He retained Rebecca Alvarez, a Columbus-based attorney specializing in HOA disputes and property law, on July 22nd. Alvarez read the file, the survey, the correspondence, the fine schedule, the enforcement log, in a single sitting, and called Marcus back, within 2 days, with a sentence he'd repeat to Linda that night, with something close to relief in his voice. "Mr. Webb, I don't think you have a boundary problem. I think you have a malicious prosecution and abuse of process problem, and I think the sign is the least interesting part of your case." Alvarez's theory, laid out in a demand letter sent to the association's counsel on August 4th, was straightforward. Diane Kessler had, according to the police report she herself had generated, knowingly and falsely reported a crime, reporting Marcus for trespassing on association common area, when no such common area existed at that location, a fact Kessler, as a 19-year resident and founding board member, could not plausibly claim ignorance of. The demand letter further argued that Section 4.12, drafted by Kessler herself and enforced exactly once in 9 years against the one homeowner in a documented dispute with Kessler's own family, constituted selective enforcement in violation of the association's fiduciary duty to apply its governing documents even-handedly, a duty explicitly codified in Ohio Revised Code, Section 53112-06. The letter demanded, within 21 days, full rescission of all fines and the threatened lien, a written retraction of the trespassing accusation, reimbursement of Marcus's legal fees to that point, and the demand that would ultimately matter more than any of the money, a formal referral of the reserve fund discrepancy to an independent financial audit, to be conducted by a CPA of the homeowner's choosing, rather than one selected by the board. Marcus just filed a demand letter accusing his own HOA president of malicious prosecution and financial mismanagement, all in the same document. Bold move, or too aggressive? What's your strategy? Tell me in the comments. The board's response, delivered by Halbrook and Vance on August 19th, rejected every demand outright. It characterized Marcus's claims as an attempt to intimidate volunteer board leadership through baseless legal threats, and reiterated that the lien would be filed the following week, absent payment of the now $4,850 balance, which had continued accruing daily fines throughout the summer, despite the demand letter sitting unanswered on Diane Kessler's desk. What the board didn't anticipate was that Marcus had spent the intervening weeks doing something else entirely. Talking to his neighbors, one driveway at a time, the way surveyors talk to landowners, quietly, patiently, with documents in hand instead of accusations. He started with the Delgados, whose relayed version of the Marcus pulled a gun rumor he corrected in person over lemonade on their porch, showing them the actual police report, which stated in Deputy Holloway's own words that no criminal activity was observed and that the complainant's description of the property boundary was inconsistent with the responding deputy's visual observation of the marked survey stake. The Delgados, embarrassed, admitted they'd never seen the actual report, only heard the group chat version. He talked to the couple on Maple Crest, whose garden bed dispute had gone nowhere in 2021, and learned they'd quietly paid a $200 fine at the time, rather than fight it, assuming the board's authority was unquestionable. He talked to the Petersons, retired now and long past the shed dispute of a decade earlier, who told him flatly that they wished someone had done 10 years ago what Marcus was doing now, and that they'd sign whatever letter or petition he needed, if it meant the next family who crossed the board didn't have to spend 18 months quietly absorbing a fine just to keep the peace. He talked to Anthony Ferraro, whose father's wheelchair ramp had sat under an active $175 a month fine for nearly a year, and who admitted, sitting on his own front step, that he'd nearly torn the ramp out entirely rather than keep fighting a board that seemed to enjoy the fight more than he could stomach. Marcus told him about the Fair Housing Act's protections for disability accommodations, protections that, as far as Marcus could tell reading the CC&R's own language, the board's Section 8.1 enforcement against the Ferraros almost certainly violated outright, a federal law that didn't care what color aluminum the board's architectural committee preferred. Anthony had never heard the term reasonable accommodation before that conversation on his front step, By the time Marcus left that afternoon, Anthony had written it down twice, underlined once, on the back of one of Marcus's own printed CC&R excerpts. He talked to 3 other homeowners who'd received arbitrary-seeming violation notices over the years: a car parked 6 inches over a driveway line, a basketball hoop deemed non-conforming, a garden flag the board decided violated the signage clause, all of whom, it turned out, had simply paid rather than push back, because nobody had ever shown them what the association's own enforcement records actually looked like. By late August, 17 homeowners had joined what Marcus and Linda started calling, half-jokingly at first, the Sycamore Ridge Accountability Group, a name that stuck, mostly because Rebecca Alvarez pointed out that a formally named group carried more institutional weight in any eventual filing or public statement than a loose collection of angry neighbors. The Ferraros joined on the group's second meeting, held in Marcus's garage around the same workbench where he'd first decided to fight back, and it was Anthony Ferraro, not Marcus, who suggested the group's second major move, reaching out to the local news. Not every conversation went smoothly. Susan Marsh, the treasurer who'd inadvertently let the "pulled a gun" rumor spread through the neighborhood group chat she administered, agreed to meet Marcus on her own porch in early August. Mostly, she admitted, out of guilt. She confirmed something Marcus hadn't been able to prove from the records alone: that the board's financial software flagged the landscaping contract's payment schedule as irregular in an automated compliance report the previous winter. A flag Susan said she'd raised at a board meeting and been told by Diane Kessler not to make a big deal out of a routine vendor relationship. Susan wouldn't sign an affidavit. She still had 2 more years on the board and wasn't ready to make an enemy of Diane Kessler outright. But she agreed, at least, to stop deleting messages critical of the board from the community chat. A small concession that nonetheless meant the Sycamore Ridge Accountability Group's flyers stopped disappearing from the group's shared folder within hours of being posted. Marcus was hesitant at first. Publicity wasn't a tool he was used to reaching for, and he worried it would make the dispute personal, in a way the documents alone hadn't. But Alvarez agreed with Anthony that a local television story, if it ran, would do something a legal filing alone couldn't. It would put pressure on the board's insurer and its collection counsel to settle, rather than let the story metastasize further, and it would make it far harder for Diane Kessler to control the narrative the way she had all summer through the neighborhood group chat. Welf 13, the Columbus area news station that covered Caldwell County, ran a segment on September 9th titled, "Fined for a Fence Line. Homeowners Say HOA Board Enforces Rules Selectively," featuring an interview with Marcus standing beside his stake and sign, an interview with Anthony Ferraro standing beside his father's ramp, and a request for comment from Diane Kessler that the station's producer noted, on air, had gone unanswered. The segment included footage of the enforcement log's most damning entries, blurred just enough to avoid a defamation problem while still making the pattern unmistakable to anyone watching. The reporter, a young woman named Jess Okafor, who'd covered county government for Welf 13 for about 2 years, told Marcus off-camera that she'd pulled HOA complaint records from 3 neighboring counties while researching the piece, and found Cedar Hollow's enforcement pattern wasn't unique in kind, only in how well documented it happened to be, thanks largely to Marcus's own instinct for keeping files. "Most people who go through this don't have 40 years of paperwork habits," she told him. "You made my job easy." The piece ran 2 minutes and 40 seconds, longer than the station's average local segment, and closed with a shot of the survey stake standing in Marcus's backyard, sign catching the afternoon light, a detail the station's editor apparently found more visually compelling than either man had expected. The segment aired at 6 o'clock. By 8, the Sycamore Ridge Accountability Group's membership had grown to 41 households. By the following morning, a homeowner from a completely unrelated subdivision 2 counties over had emailed Marcus through the group's newly created contact address, describing a nearly identical fine dispute over a paint color and asking, almost pleadingly, how he'd built his case. Marcus wrote back with a list of the specific CC&R sections and county recorder resources he'd used, the closest thing to a public service he figured a retired surveyor had left to give. The group's first formal act was collective, a joint public records request, submitted under 17 separate homeowner signatures on August 28th, filed even before the news segment aired, timed deliberately by Alvarez to be already sitting on the board's desk when the story broke. For the complete unredacted financial records the board had partially withheld from Marcus's earlier request. It was a request the association's own bylaws obligated the board to fulfill for any group of members representing at least 5% of the community, a threshold the 17 signatures cleared with room to spare. The board, perhaps sensing the walls beginning to close, tried a different tactic entirely on September 2nd. An offer, delivered privately to Marcus through Halbrook and Vance, to waive the entirety of his fines, now standing at $6,150, in exchange for his signing a non-disclosure and non-disparagement agreement and formally withdrawing from any further collective action against the board. Marcus read the offer twice at his kitchen table, then called Rebecca Alvarez. "They're offering to make it go away," he told her. "If I shut up and walk away, what do you want to do?" Marcus looked out his kitchen window at the stake still standing in his backyard, sign intact, exactly 11 feet inside his own property line. "I spent my whole career getting lines right," he said. "I'm not spending the back half of my life pretending this one doesn't matter. And I'm not doing it while Anthony's father can't get down his own front steps without the board fining him for it." He rejected the offer the same afternoon. The fourth move, and the one that finally cracked the dam, was Renata Hicks. Renata was one of the two at-large board members, a quiet woman who'd sat through 6 years of board meetings mostly saying nothing, mostly voting, however Diane Kessler's agenda suggested she should vote. On September 14th, 5 days after the Wealth 13 segment aired, she called Marcus directly, something no sitting board member had done since this began, and asked to meet privately at the Millbrook Falls Diner off Route 9, well outside Cedar Hollow's borders. She told him 3 things that day, over coffee she barely touched. First, that she had voted against Section 4.12's adoption back in 2015, and had been the lone dissenting vote, precisely because she'd found the language dangerously vague even then, though she'd never imagined it would end up used the way it eventually was. Second, that the reserve fund shortfall wasn't stormwater repairs at all, that in a closed-session board discussion in early 2024, Diane Kessler had disclosed the money had gone toward a consulting contract with a landscaping firm, owned, as it happened, by Diane Kessler's brother, a contract Renata said she'd never seen competitively bid or independently reviewed, and one for which she'd never personally seen an itemized invoice. Third, and this was the one that made Marcus's hands go still around his coffee cup, that Diane Kessler had told the board in the same closed session that she intended to make an example of Marcus's boundary dispute, specifically because it was, in Kessler's own words as Renata remembered them, the kind of thing that reminds people who runs this neighborhood. Renata also told him something that hadn't made it into the news segment, that the Ferraro fine had come up in that same closed session, and that Diane had specifically opposed granting the Ferraros any accommodation, telling the board that if we bend the rule once for a ramp, everyone's going to want an exception for something. Renata agreed, after 2 more meetings and considerable hesitation about what it might cost her socially in a neighborhood she still had to live in, to put her account in a signed affidavit. After everything Marcus went through to get here, was it worth it? Have you ever fought your HOA and won? Or did you walk away? Tell me your story below. I want to hear it. The reckoning came on October 21st, at the association's annual meeting, held in the Cedar Hollow Estates Clubhouse, a beige-carpeted community room that could technically seat 80 people and had never, in Marcus's 19 years living there, come close to being full. This year, it was standing room only. Word had traveled. Not through Diane Kessler's social circle this time, but through the Sycamore Ridge Accountability Group's own channels. A flyer, hand-delivered to every one of the 206 homes in the community, laying out in plain language the boundary survey, the enforcement log discrepancy, the reserve fund shortfall, the Ferraro ramp fine, and Renata Hicks's signed affidavit, all of it backed by document numbers and dates, rather than rumor. 134 homeowners showed up, more than triple the quorum requirement, and more than had attended the previous 6 annual meetings combined. Diane Kessler opened the meeting, attempting to stick to a prepared agenda: landscaping bids, a proposed pool assessment, routine business, and made it 11 minutes before Rebecca Alvarez, attending as Marcus's legal counsel and a member of the public, entitled to address the floor under the association's own open meeting bylaws, stood and asked to be recognized regarding an item of significant homeowner concern not currently on tonight's agenda. "This isn't on the agenda," Diane said, gripping the podium. "With respect," Alvarez said, "under Article 4, Section 4.6 of your own bylaws, any member in good standing may raise new business with a second from the floor. I believe I have several seconds already standing in this room." At least a dozen hands went up before she'd finished the sentence. Diane looked out at the room, at faces she'd known for years. Some of them, people whose proxy votes had kept her in office 6 years running. And Marcus watched something shift in her expression when she realized how many of those same faces weren't looking at her the way they used to. "Fine," she said, her voice tighter than the word suggested. 5 minutes. That's it. It'll take as long as it takes," someone called from the middle rows, and a ripple of agreement moved through the folding chairs. Diane sat back down at the board table, and for the first time in 6 years, it was someone else's turn to talk. What followed was, by every account Marcus later heard, the longest 90 minutes in Cedar Hollow Estates' 21-year history. Alvarez laid out the timeline methodically. The licensed survey confirming the boundary sat entirely on Marcus's property. The fine schedule under a rule enforced exactly once in 9 years. The waived fines at 3 addresses, connected to board members and their families, Diane Kessler's own daughter among them. The Ferraro ramp fined nearly $2,300 over a wheelchair accommodation for a stroke survivor, a fine Alvarez noted, to visible discomfort from several board members, likely violated the Fair Housing Act's reasonable accommodation requirements outright. The reserve funds decline from $184,000 to $61,000, and the unbid landscaping contract awarded to Kessler's brother. And, finally, Renata Hicks, who stood, visibly shaking, and read her own affidavit into the record, rather than let it be summarized second-hand, confirming in her own voice what Diane Kessler had said in that closed session about making Marcus an example and about refusing to bend the rule for the Ferraros. Diane tried to interrupt twice more during Renata's reading, both times cut off by Rebecca Alvarez citing the same bylaw section she'd opened with, and both times the room's patience for Diane's objections visibly thinning. By the third interruption, it wasn't Alvarez who told her to let Renata finish. It was Gary Poole, sitting 2 seats down the board table, who said, quietly but audibly, through the room's sound system, "Diane, let her talk." It was the first time in 6 years anyone recalled Gary Poole publicly disagreeing with her about anything. A murmur went through the room when Renata read that last line. Anthony Ferraro, sitting near the back with his father, in a wheelchair beside him, said nothing, but Marcus watched him grip the armrest of his father's chair, hard enough that his knuckles went white. Gary Poole, the second at-large board member, sat frozen through most of it, and when a homeowner from the floor directly asked him whether he'd known about the waived fines, he answered, quietly but audibly, "Not the specifics, but I knew things weren't being applied even-handed. I should have said something sooner." Diane Kessler tried, twice, to regain control of the floor, first by questioning Renata's motives. "She's had a personal grudge against me since the 2021 election, and everyone in this room knows it," a claim two other homeowners immediately contradicted from the floor. Then by threatening to adjourn the meeting entirely, a move Rebecca Alvarez calmly informed her would violate the association's own bylaws, requiring a board vote to adjourn early. A vote that, given the room, Kessler would almost certainly lose. "You don't get to just walk away from this," someone called from the back of the room. Marcus never found out who said it, but he'd think about that line for a long time afterward. The motion that ultimately came from the floor, proposed by Frank Delgado, seconded within seconds by no fewer than 6 other residents, called for the immediate recall of Diane Kessler as board president and her removal from the board entirely, per Article 7, Section 7.3 of the CC&Rs, which permitted removal of any officer by a 2/3 vote of members present at a properly noticed meeting where the matter had been raised. Alvarez confirmed, for the room's benefit, that under the association's own governing documents, an emergency recall vote could proceed that same evening if the 2/3 threshold for calling the vote was met. It was met by acclamation before anyone bothered counting hands formally. The recall vote itself, tallied by Todd Averill, who, to his credit, ran it fairly once it became clear which direction the room was heading, passed 121 to 13, with a handful of abstentions. Diane Kessler was removed as board president and as a board member effective immediately. Renata Hicks was elected, that same night, to serve as interim president, pending a full board election in the spring. Todd Averill resigned voluntarily the following week, rather than face a similar recall vote, citing, in a brief letter to the community, his discomfort with decisions made during the prior administration that he should have questioned at the time. "After everything he went through, do you think Marcus should have pushed for criminal charges too, or was the recall enough? Tell me what you would have wanted." The legal side of the story took longer to resolve than the political side, which Marcus found, in a way, appropriate. Surveying had taught him that the ground under a dispute always settles slower than the noise above it. The mediation session itself, held in a conference room at Halbrook and Vance's offices in downtown Columbus on a gray morning in January, was the first and only time Marcus sat across a table from Diane Kessler after the recall vote. She'd brought her own attorney, a heavyset man named Phil Draskovic, who spent most of the session's opening hour arguing that the association's insurer, not Diane personally, should bear any settlement cost, an argument the insurer's own counsel firmly rejected, given how squarely the malicious prosecution claim targeted Diane's individual conduct rather than any board decision. Diane said almost nothing for the first 2 hours. It was only when the mediator, a retired judge named Constance Farrow, read aloud a portion of Renata Hicks's affidavit into the record, the line about reminding people who runs this neighborhood, that Diane finally spoke, her voice smaller than Marcus had ever heard it. "I built that rule to protect this neighborhood from turning into a mess of unresolved arguments between neighbors," she said. "I never meant it to be used the way it ended up being used." "With respect, Mrs. Kessler," Alvarez said, "the record shows you used it exactly once, against a man whose daughter's fence sat on his land." Diane didn't answer that. She looked, for a moment, less like the woman who'd stood in Marcus's backyard with a clipboard under her arm, and more like someone finally hearing, out loud, in a room full of lawyers, the version of events that had been circulating through Cedar Hollow for months, without her in the room to shape it. Judge Farrow called for a break shortly after, and by the time the parties reconvened that afternoon, Draskovic had shifted from arguing liability to negotiating numbers, which was, everyone in the room understood without saying so, the moment the case had effectively been decided. Rebecca Alvarez's malicious prosecution and abuse of process claim against Diane Kessler personally, along with a separate claim against the association for breach of fiduciary duty tied to the selective fine enforcement and the unbid landscaping contract, moved through mediation over the following 4 months. Facing Renata Hicks's affidavit, the police report's own language, confirming no crime had occurred, an enforcement log that a mediator described in the session as about as one-sided a document as I've reviewed in this line of work, and the very real possibility of a separate federal fair housing complaint tied to the Ferraro ramp. The association's insurer pushed hard for settlement rather than risk a jury seeing the same documents Marcus's neighbors had seen at that October meeting. The settlement, finalized in late February, required the association to formally rescind all fines against Marcus in writing. The balance had by that point climbed to $6,850 before enforcement was suspended pending the outcome, reimburse his legal fees in full, and issue a written retraction acknowledging that the April 25th trespassing complaint had been unfounded. Diane Kessler, sued in her personal capacity for the malicious prosecution claim specifically, settled separately for an undisclosed sum that Marcus's attorney indicated was meaningful, though the terms remained confidential. The Ferraro's case resolved separately and, in some ways, more decisively. Facing the near certainty of a Federal Fair Housing Act complaint, the new board under Renata Hicks voted unanimously in November to rescind the Ferraro's entire fine balance, reimburse the nearly $700 they'd already paid, and formally amend Section 8.1 to exempt medically necessary accessibility modifications from architectural review entirely, a change Anthony Ferraro would later say meant more to him than any dollar amount could. Separately, the new board commissioned the independent financial audit Marcus's original demand letter had requested. The audit, completed in April, confirmed the landscaping contract awarded to Diane Kessler's brother had never been competitively bid as the association's own procurement policy required, and that invoices submitted for the work totaled roughly $70, less than what had actually been withdrawn from the reserve fund over the relevant period, a gap the auditor's report described, carefully, as unsupported by documentation currently available, language that fell short of an outright fraud finding, but was damning enough that the new board voted unanimously to refer the matter to the Caldwell County Prosecutor's Office for further review. As of this telling, that review remains open. The auditor, a CPA named Howard Lien, retained specifically because he had no prior relationship with anyone on either side of the dispute, presented his findings at a special session in April, attended by roughly 60 homeowners, considerably fewer than the October meeting, but still more than Cedar Hollow had ever gathered for a financial report in its history. Lien was careful, in his presentation, to draw a clean line between what the numbers showed and what they proved. "I can tell you the money that left this account doesn't match the invoices I was given," he said. "I can't tell you where it went. That's not an audit question anymore. That's a different kind of question, for a different kind of office." Diane Kessler's brother, reached separately by a Caldwell County detective in May, according to a brief item in the Millbrook Falls Courier, declined to comment through his attorney. Renata Hicks, standing at the same podium Diane Kessler had once gripped so tightly, closed that April meeting by reading aloud the new reserve fund policy the board had adopted unanimously the week before. Competitive bidding required for any contract over $2,500, quarterly financial disclosures posted publicly rather than distributed only on request, and an independent review of the reserve fund every 3 years going forward, regardless of whether any resident asked for one. It was, several longtime homeowners remarked afterward, the most boring 30 minutes Cedar Hollow Estates had produced all year, and every one of them meant it as the highest compliment they had. Section 4.1, the boundary dispute rule Diane Kessler had written and enforced exactly once, against Marcus, was formally repealed by a homeowner vote at a special meeting in May, replaced with language requiring any boundary complaint to be supported by an independent licensed survey before any fine could be issued, and prohibiting the board from unilaterally imposing daily accruing fines on any disputed matter without a majority board vote taken in open session. Marcus's stake still stands in his backyard, 11 feet inside his property line, sign intact. Nobody's called the sheriff about it since. The Burns, for their part, rebuilt the fence on the correct line in June, at their own cost, without another word passed between the two households beyond a curt nod at the mailbox. So, Marcus Webb kept his sign, got his money back, and helped remove the entire regime running his HOA. Was it worth every ounce of the fight? Have you ever gone up against your own board and won? Or walked away instead? Tell me your story below. I read every single one. Marcus doesn't talk about it much these days, mostly because there isn't much left to say. He still walks the neighborhood most evenings, still notices property lines the way other retired men notice birds. He sits on the new Architectural Review Committee now, a volunteer role Renata Hicks asked him to take on personally, on the theory that a man who spent 4 decades getting boundaries exactly right was probably the last person in Cedar Hollow Estates who'd ever let a rule get applied unevenly again. Anthony Ferraro joined the same committee 2 months later, at Marcus's suggestion, on the theory that the board could use someone who'd actually lived through what an uneven rule could cost a family. Diane Kessler and her husband put their house up for sale in July and moved 2 counties over. Nobody at the block party this year seemed particularly sorry to see the sign go up in their front yard instead. The Sycamore Ridge Accountability Group never formally disbanded. It simply changed shape the way these things do once the crisis that created them passes. A handful of its 41 households still meet every few months, informally, mostly to keep an eye on the new board's spending and to make sure nobody on it ever again mistakes 6 years of unchallenged authority for a mandate. Renata Hicks was elected to a full term as president that spring. Unopposed, the first uncontested election Cedar Hollow Estates had held in over a decade, though she'd tell anyone who asked that she'd rather have run against somebody than run unopposed, if only because a real contest felt like proof the neighborhood had learned something. Anthony Ferraro's father passed away quietly the following winter, in his sleep, in the bedroom the family had built out for him on the ground floor, specifically so he wouldn't need the ramp for much longer than he ultimately did. Anthony left the ramp up anyway, unpainted aluminum and all, long after anyone in the county could have fined him for it. He told Marcus once, at an Architectural Review Committee meeting, that he liked seeing it there. Said it reminded him what fighting for something small can end up meaning to somebody who needed it. Marcus still keeps the exhibit binder in the same fireproof filing cabinet where he keeps everything else. Tabs a little worn now from how many times he's pulled it out to show a curious neighbor or a reporter, or, once, a homeowner from 3 counties over who drove out just to shake his hand. He doesn't expect to need it again, but he's a surveyor. He knows better than most people that a line, once disputed, rarely stays settled just because everyone agrees to stop talking about it. So the binder stays where he can reach it, same as the stake stays in the ground, same as the sign stays zip-tied where it's always been. Not a threat anymore, if it ever really was one, just a marker, exactly where the truth of it always sat. If there's a lesson in any of this, Marcus figures it's the one he already knew from 4 decades of professional practice, the one that just happened to apply somewhere he never expected to need it. A line on a piece of paper only means something if somebody's willing to stand on it when it counts. He's still standing on his.